Let's move to the story now. The Pretoria High Court has today ruled in favour of media outlets amabunghane and the Financial Mail in their bid to access former President Jacob Zuma's tax records. The tax authority, SARS, had been opposing this move as privacy of tax matters is a crucial arm of how they collect their dues. But the court today found the tax authority's blanket approach to privacy was based on aspects of tax law that are not constitutional. Let's find out what that means. I'm joined by media law attorney Dario Milo, who acted on behalf of amabunghane and the Financial Mail. Dario, thank you so much for joining us. So is this a win for public interest over the right to privacy in tax matters?
It definitely is, and hello to all your viewers. It definitely is a victory for transparency and for the issue of public interest override being applied to tax information in just the same way as it applies to all other categories of information under our access to information legislation.
All right, so does this mean that, my understanding is that you've successfully argued that part of the Tax Administration Act, also PIA, are unconstitutional. So does that mean it has to be sort of rubber stamped by the Constitutional Court? What is the next step?
Yes, that's absolutely right. Whenever the High Court strikes down legislation and says that it's unconstitutional, it has to go to the Constitutional Court to be confirmed. So the Constitutional Court needs to look at it afresh and to decide whether they agree with the High Court. So here what the High Court has done is it has said that when you, as the media, for example, in this case, applied for access to, in this case, President Jacob Zuma's tax returns, there was a section in PIA, there is a section in PIA, the Access to Information legislation, which says that there is an absolute rule of secrecy around that information. The Revenue Authority can't make that available, it can't disclose that information under the Access to Information legislation, and that is buttressed by the tax administration laws, which also contain that absolute rule. But what the High Court has done after our argument in this matter is it has said that just like other categories like national security information, trade secret information, and indeed legal privilege, in all the other categories of information, there is a balancing to see if there is a public interest in the disclosure. And in particular, if there is a substantial contravention of the law that the disclosure of the information would reveal, then it should be made available to the public. And that's what the High Court's done. It said that the public interest argument in the Access to Information Act now also applies to tax information.
What if SARS appeals? Does that halt the process of going to the Constitutional Court to confirm this ruling today?
It doesn't halt the process because SARS doesn't have to appeal that aspect of the case. It automatically goes to the Constitutional Court to be confirmed. In other words, the fact that the Tax Administration Act and the Access to Information Act were both in part struck down as being unconstitutional. What SARS could do is it could appeal the other aspect of the case, which is that within 10 days, on the facts of the particular case, SARS has to give to Financial Mail the tax records, the tax returns of former President Jacob Zuma for that period of 2010 to 2018. That has to be done within 10 days. That's the other layer of the case. And of course, SARS might appeal that or apply for leave to appeal that part of the case, which would then suspend that particular order until the appeal is.
Why is it in public interest that we get to understand what was going on with Jacob Zuma's tax records between 2010 and 2018 while he was president?
Well, it's a good question, and to answer that question, you have to go back to the book, The President's Keepers, because that's what really triggered that access to information request by the Financial Mail. In that book, the allegations, there were a number of allegations about President Jacob Zuma's tax status. One was that he hadn't filed tax returns for the first 7 years, for the 7 years of his presidency. Another was that he had received R1 million sum for the first few months of his presidency from a security company, and the allegation is that he hadn't paid income tax on that amount. Another allegation is that he hadn't declared fringe benefit tax and paid fringe benefit tax on the eNCA security upgrades, and other allegations as well. So the book aspects of which, of course, were confirmed in later inquiries. So, for example, the Public Protector's secure in comfort report said that indeed the upgrades to the Nkandla residence were a form of fringe benefit. All of that meant that there are serious allegations about the tax compliance status of the former president. And in that context, the argument is that it is a matter of public interest for the tax returns to be revealed. Maybe I'll just pause there to say, as a result of this case, it's not that the floodgates will be open and that everyone's tax returns are now public. Not at all. There is still a general rule of confidentiality. But when you bring an access to information request, SARS now has to consider, and of course Parliament has 2 years to fix the law as well, but in the interim period, if the Constitutional Court confirms this, SARS would have to consider whether there is a public interest in the disclosure of that information that's requested. And if there is a public interest, SARS would have to make it available to the taxpayer, to the requester, even though it involves confidential information about a taxpayer.
All right, well, thank you so much. Media law attorney Dario Milo, who acted on behalf of amabunghane and the Financial Mail today.